Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records, and welcome to this morning's webinar, where we're going to be talking about basics of the right to know law. Let's go over a couple preliminaries before we jump into the actual presentation. First is that if you've never sat through one of these webinars before, it is PowerPoint based with me discussing the topic in the background. The PowerPoints are available on our website. You would tab over to the, or scroll over to the training tab and go down a little bit, and you can find all of the PowerPoints that we use for our trainings. And you're welcome to use any of them. Maybe you've got a coworker or colleague who couldn't make it this morning, and it would be helpful for them. You can use it for your own future reference, or maybe you're conducting some local training and you'd find the slides helpful. Feel free to, like I said, download them and use them as you see fit. Also, this session is being recorded, and typically the way it works is that the recording a couple days after the session is reviewed by our administrative staff. They do some minor editing just to make it more user-friendly. It gets uploaded to our YouTube channel, and then a link is established on the website. Again, scroll over to the training tab, and you'll find all of the most recent recordings of webinars that we do here bi-weekly. And you can download them. Or if you're really interested, I think what you do is contact the office and ask to be emailed a link. And then using the current technology, they do that. They would email you a link to the page that would allow you to share it, or they would share it with you, and then you would have access to the recording. And again, it could be maybe you've got some folks who are busy this morning and couldn't attend the session. Perhaps you're conducting, your own training locally, and having access to the recording would be helpful. It's interesting because we consider all of these to be public records. So you have immediate access to them, or not immediate, but you have certainly have access to them. All you have to do is ask. The other thing that I want to make clear is that given the format, I will do my best to answer questions as we're going through the presentation. You can type your questions into the chat feature. And I'm sitting here, watching this go by. So I'll do my best to answer as we're going through the presentation. But there's two conditions. First is that we're talking about the right to know law this morning, so let's stay on topic. Second, and probably more important, is that it's really critical that you try to keep your questions as brief and succinct as possible. Every so often, folks will type in several paragraphs, and it's awkward for me to sit here, read through that while everyone else is patiently waiting. And we'll do, if your situation, if your question is unusually complex or unique to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll do my best to come back to it and address it for the good of the order, or we'll take the conversation offline, meaning you can reach out to our office with your question. Contact information is on the screen right now. You can phone in, or you can go to the website where you'll find email accounts that will allow you to email your question in. Whether you call or email, the first point of contact will be one of our administrative staff. They're all well-versed on the right to know law, and 95% of the time they can help you out. If by chance you have something that's really unique and they can't help you out, your question will get escalated to one of the senior staff, and they do their best to get back to you, typically within 24 hours, although quite honestly, lately, just given the workload, which, every day it seems like we're breaking new records, for the most requests, the most appeals ever handled by our office, say in May. It's just getting harder and harder to get back to you. But we realize if you're reaching out to us, it's probably time sensitive and it's probably important to you. So we will do our best to get back to you and help you get steered in the right direction. Couple caveats: we can't write requests for you, we can't answer requests for you, and we certainly can't discuss any active appeals. But we will do our best to get you steered in the right direction and hopefully help with whatever situation you have. Okay. All that being said, all those preliminaries out of the way, let's jump into this presentation. Okay, first I want to talk about just why is the right to know law important. And it really has to do with access to public records, government transparency, and good government overall. I want to start with this fundamental statement because there is a lot of misunderstanding. The right to know law has been around since 2010, and it still surprises me how many people don't fully understand just what the right to know law is intended to do. And this is a very fundamental statement that every so often someone will call with a situation where they're just confused, they don't know what to do next or whatever. And I try to bring them back to square one. The purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, that's what it's all about. Some folks look at the right to know law and they think it's some form of Google for government. And it's not, okay? It's not the intention of the right to know law for folks to query us with questions and then we're obligated to run around and try and find out the answer. That's not what the right to know law is. The purpose of the right to know law is to give access to public records. A lot of times it comes down to possession. Do we in fact have those records in our possession, or is there a record that effectively addresses the problem that the person has? And is it in fact a public record? Is it something that we can release, and is it something that we choose to release under the right to know law? Now, that being said, we need to keep in mind that the starting point is that every record in the possession of an agency, everything that you could find on an agency's computers, on their cell phones, in their file cabinets and so forth, is presumed to be public, okay? And that this is where the law is coming from. And that's your starting point. Now, when I say that, or when people first hear that, maybe it's their first right to know request, maybe they're learning about the law for the first time, and they hear that statement, and they get all wigged out and think, oh my gosh, everything in our computer, everything in our file cabinet, everything in our office is going to end up on the front page of the paper tomorrow morning, or it's going to be on somebody's Facebook page or whatever. And I'm here to tell you that's not the case, okay? There are a lot of records that typically a government office would have in their possession that are not public, okay? And in the right to know law, as you get into it, you'll find that there are tools and protections built into it that, if you get a right to know request and a red flag goes up and, just a concern, it's like, you know what, I'm not sure, I'm not comfortable with the idea of releasing this out to the public. Chances are you're going to find either something in the right to know law or another law that would deem that record as confidential. Okay, that's not always the case, and that's why we have appeals and a body of case law to provide clarification on what can and cannot be released. But your starting point is that everything is public, unless the agency can meet its legal burden of proving that a record is not public, and that would be through using one of the tools available in the right to know law or another law that may deem a record as confidential, okay? Now, you can't just say, or the agency can't just say, well, we're not releasing that. The agency has to prove, through a legal argument, that the record is not public. It could be as simple as saying that this record, if we would release it, would cause, it would bring physical harm or a significant chance of physical harm to an individual, or it would create a threat to the security of our computer systems. Okay, and then tie that into specific language within the right to know law. Okay, so you make that nexus. This is the record you're requesting. We've determined that by releasing these records, it would create a threat to our computer infrastructure, and you can find that provision within the right to know law by citing that appropriate provision. Okay, and that's how the agency would meet its legal burden. If the agency can't meet its legal burden, then there's a good chance that the record is public and it's responsive to the request and should be released. Okay, so in a nutshell, that's how the right to know law works. But if you're, say, a new agency open records officer, right to know officer, by the way, those two terms are interchangeable, open records and right to know. There's no difference between the two. But if you're new and you encounter a right to know request and for whatever reason, it just gets confusing and you're not sure which way to turn, I really recommend coming back to this fundamental statement. And a lot of times it will, it represents a reset, okay? Kevin, enlighten me, what part of section 705 do you need to discuss? Okay, we have a question here about discussing 705. And I don't have the law in front of me at this point. Okay, we're going to move on. Creating records. Oh, okay. Just real quick, the question often comes up. Well, first offhand, 705, to paraphrase, says that an agency is not required to create a record in order to respond to a right to know request. There are 2 points that I want to make in response to Kevin's question, which is a good one because this comes up more often than you realize. First is the practical perspective of it. Okay, let's say someone requests a list of public employees who are employed by your agency. And there's really not a single list of public employees. Well, you could argue that that record doesn't exist, okay? And in order to have a record like that, in order to provide the list, we would have to create a record. So we're going to deny your request. All right, well then the person, they think, well, this is an obvious response. I'm going to file an appeal. Well, suddenly your solicitor's involved, you're running around helping the solicitor and so forth, when the alternative could have been, why can't I just sit down and type out a list and provide it? Then the requester's happy and I can get back to the important work that I was doing before I got the request. Okay, sometimes, and this is my point, sometimes it's just easier to create the record, okay? You've got to look at, which is the path of least resistance. And, my advice sometimes is just create the record. And that way your customer, your citizen, your taxpayer is happy. And it doesn't really represent a lot of work on your part. Typically, a lot less work than it would be to respond to an appeal and all of the legal wrangling that takes forth when a person files an appeal. The second point that I want to make is looking at case law related to Section 705. And there, the seminal case is called Gingrich versus the Pennsylvania Game Commission, where Mr. Gingrich requested a series of records that had to be peeled from a database that the Game Commission has. It got appealed all the way up to the courts, and I think it was the Pennsylvania Commonwealth Court ruled that the database is the record. The report that Mr. Gingrich was requesting, which typically the Game Commission didn't have, they would have to go into the database and generate a custom Excel spreadsheet. That is simply a report reflecting the record. So, I don't want to get off into a rabbit trail with case law, but case law is important. And it addresses Kevin's question where there are exceptions, where in some cases the court has said you do have to create a record. Walt, the case is Gingrich versus the Pennsylvania Game Commission. Okay, Joan, you're a couple slides ahead of me, but yes, you can have more than one open records officer. Okay, so very good question. Yeah, hopefully I've answered it. So let's move on. Now, this is another important point in that the right to know law is not a confidentiality law. Oops, other questions are popping up. All right, folks. Okay, yeah, I'll just do my best to answer these. What about salary with employee lists? Can an agency point the requester to PennWatch to look up themselves? Yeah, you guys are drinking too much coffee this morning. You're getting ahead of me with some slides, but you know what? They're good questions, and I don't mind getting out of order here. If you have a record that is on a website or some publicly accessible electronic format, and someone requests it through Right to Know, your response can be, that's on our website, here's the link to the website, and you point them to the record that they're looking for. That's completely acceptable, okay? And it's a provision of the Right to Know law. Good question. Next one. Can anyone other than the open records officer retrieve information for the public? That depends. The role of the Right to Know officer is to receive, process, and respond to Right to Know requests. Okay, but you can have other staff who are more closely familiar with the records actually providing those records to the open records officer. Now, the open records officer is the one who's legally responsible for responding to the Right to Know request, but you can have other folks helping you out, okay, if that helps you with your question. Okay, now let's go back to the slide here. Good questions, by the way, folks. The Right to Know law is not a confidentiality law. Okay, what do I mean by that? Well, first off, Ann, there's nothing preventing an agency from giving out public records outside of the Right to Know law. There's nothing in the Right to Know law that says this must be used in order to give out public records. A quick example, let's say it's budget season, and within the office on the counter, there's a stack of budgets. I'm Joe Q. Citizen. I come walking into the office and I'd say, I'd like a copy of the budget, please. You can simply hand me that copy and I go out the door happy. There's nothing that says you must use the Right to Know law to give out copies of the budget. Now, what if I come walking in with a Right to Know request that says, I'd like a copy of the budget? You can go so far as to say, you know what, George? I've got a stack of budgets here. If you tear up that Right to Know request, I can simply hand you a copy and it'll save you a lot of time. and it'll save me a lot of work. Now, why wouldn't I do that? Because I'm getting what I want and you're saving yourselves a lot of work. And everybody's happy. Okay, so you can do that. Now let's take this up a step. What if I say, no, I want to follow the right to know process? Well, then you have to. Okay, if I say this is a right to know request and I want to proceed with it, then it could take me up to 35 days before I get a response. But, shame on me for wanting to do that. And you would have to adhere to that. The other thing that I want to suggest is that you can be reactive or proactive with, like I said earlier, about putting records out there on your website, okay? And take a look at what people are most commonly requesting, okay? What do they want from you? What are the trends? Budgets, contracts, salary information, purchasing documents, and the like, okay? Maybe there's some hot button issue that your agency is dealing with. And when I use the term agency, that's a generic term. We're talking about state agencies, boards, commissions. Locally, we're talking about cities, townships, boroughs, school districts, authorities, and the like. Okay, everybody's covered. But, what are people most commonly looking for? And then be proactive and put them out there on your social media sites. So that, like we were talking about earlier, when you get a request, now you can simply say, that's on our website, here's the URL, and that is considered a legally valid response under the right to know law. And you'll notice a couple of things. It reflects what the public wants nowadays. It's much easier to sit in the comfort of your family room on your laptop, search the agency's website to get the records that they need. As opposed to taking an afternoon off from work, coming down and filing a right to know request or whatever, and potentially waiting 35 days before they get a response. Also, you'll notice that hits start going up on your website, but right to know requests start going down, which is a good thing, okay? It may be a little more work up front that saves you a lot of work over the long haul, okay? So, there's nothing in the right to know law that requires this, although occasionally there have been proposals coming out of the legislature. But it is a good thing because it could save you work in the long run, and we're all interested in saving work and serving the public as best we can. Okay, moving on. Let's talk about the agency obligations. And the first and most important is that an agency must appoint an agency open records officer. And like the question earlier, you can have more than one agency open records officer. All the right to know law says is that it has to be either a public official or a public employee. So that could be, it could be the mayor, it could be the president of council, it could be the head of the township supervisors, it could be the school district superintendent, or it could be the nice lady you meet when you walk in the front door and she's sitting there at the front counter. Okay, it doesn't matter. As long as it's clear to the public, who do I give this right to know request to? So you can also, like I said, have more than one, and many agencies will do that. A good example might be a borough, where they have one agency open records officer for like the administrative side of all operations, and then there's a second one for the police department. Okay, because maybe they're in a separate building or whatever, and police records are unique, so they have their own agency open records officer. But again, there's nothing in the law that requires this, but it does give you that option. And when we're talking about a backup, like was mentioned with the question, I think that's a great idea. because if someone's off sick or they're on vacation, there's someone who can step in and keep the process moving if you have more than one agency open records officer, or if there's like an alternate in place. The Office of Open Records has one agency open records officer, but when you file a right to know request with our office, it comes into a central email account that I think a total of 3 people have access to. And like I said, it keeps the process moving so that there are no unexpected delays. Police departments are not exempt. Well, no, police department records can be subject to and discoverable under right to know. And we do a separate webinar on right to know law for law enforcement. In case you're interested in that, it should be scheduled within, probably within the next 2 months. But you might want to educate yourself with that. Okay, so back to agency obligations. Agencies can come up with their own localized policies under the right to know law, as long as they are consistent with the law and don't conflict with any policies promulgated by the Office of Open Records. A quick example is that in the right to know law, there is a section that says an agency may accept anonymous requests. In Pennsylvania, there's another law called the Statutory Construction Act, where that word may can also be interpreted as may not. So yeah, go figure. So applying this standard to that provision in the right to know law, it means that agencies can choose not to accept anonymous requests. You just need to adopt that as part of your policies or procedures and make sure that it's publicly displayed on your website or office postings or whatever, that you will only accept right to know requests where the requester is identifying themselves. All right. And that's an example of the flexibility of how the right to know law gives you that discretion. Do you have any examples of policies that exclude anonymous requests? No, we don't necessarily do, because you would have to simply craft that language and make sure that it's publicly posted. It seems rather obvious, just some indication that all right to know requests must include information that clearly identifies the requester. Okay. You can look at, Michelle, you can go to our website, go into the final determinations database, and probably put in the term anonymous requester or anonymous or something like that. And cases will come up that you can read where you can get an idea as to how this standard applies. Okay, that's what I would recommend. Okay, moving on. Many agencies will create their own right to know forms, and that's fine. They like their seal at the top, perhaps contact information with the arrow, but you must accept the state form if someone comes in with it. And there's nothing special about the state form. It's on our website. Some agencies will actually link to it and use that, and that's fine too. But just keep in mind that you can require a person to use your own form, but if they use the state form, that's acceptable. Okay, that's legal. And then finally, we ask that you let us know here at the Office of Open Records who your arrows are. On our website, again, there is a searchable database of arrows statewide. Sometimes it's not obvious on the agency website. Who do they give this to? So they contact us and they can go through our website, hopefully find the right person. If it's not accurate, maybe one of the takeaways from this morning is to check out our website, make sure that your agency information is up to date. If not, there's a form there for you to fill out and email to us. We will verify it and then update the database accordingly. Okay. The other thing that makes this important is that if an appeal is filed against the agency, it is the agency open records officer that we reach out to. So it's important that this be kept up to date. Okay, postings. You're required to have postings on your bulletin boards. And if you have a website, it needs to be on your website. You know, I want to emphasize that the importance of this is to educate the requester, okay? The more the requester knows about the process, the easier it's going to be for everybody. People don't like surprises. They don't like wrenches being thrown into the process that they're not expecting. So the better you can educate them on how your process works, the easier it's going to be to get to the finish line and provide the records that are being asked for, or explain why these records are not available for public release. So on your bulletin boards, websites, you want to have the contact information for the AARO. Remember what I said. I'm the public. I'm not really familiar with this process, but apparently I have to do this. Who do I give this right to know request to? Okay, that's really important as a starting point. And then contact information that if you deny my request, how do I appeal it? Because I have a legal right to do so. In 95% of the cases, it's going to be to the Office of Open Records. What I recommend is you provide the URL for our website, because when you file an appeal with our office, you do it electronically on the website. And that feeds into our docketing system. And it's just the easiest way to interact with our office. Then you want to have a form. You know, if the person doesn't have a form themselves, you provide one for them. So you need to have, supply in your office. And ideally, you would have like a PDF on your website that I could download and complete. Some agencies actually have those, fillable forms that, I can they have an electronic system that would allow me to fill out a right to know request right there on their website and enter it, and it goes into their system. Okay. And if you have the resources to do that, great. If not, we understand. But, and again, there's nothing in the right to know law that requires that, but they just make it easy for the public. And then if you do have any of those local policies or procedures that you want the public to follow, that needs to be posted as well. Okay. Let the public know what the rules are before they ever enter the playing field. And trust me, things will work out easier for you as you're shepherding them through this process. I'm going to get a quick sip of coffee here. Yeah. What are things that you cannot do with the right to know? Well, you can't compel a person to tell you why they are filing a right to know request. Okay. You can't deny a request based on the reason or what you think the reason is. Okay. Let me just go off script here a little bit and get on my soapbox. The majority of people who file right to know requests have a legitimate problem that they need to solve by obtaining a public record. Okay. But there are a handful of folks who have, for whatever reason, the relationship between the agency and them has broken down. Maybe they got a parking ticket. Maybe they didn't like the size of their tax bill last year. Maybe they don't like who was elected to council. And they've decided they're going to be a pain in the neck. And one of the ways that they're going to be a pain in the neck is weaponizing the right to know law and filing a lot of frivolous requests. Okay. Just because you think they're filing right to know requests to make you work harder, unfortunately, that's not a valid reason for denying the request. My experience has been when you're dealing with a frivolous requester, the solution lies on the payment side of the right to know law. Now, we're going to talk about it briefly, but we also have another webinar that focus specifically on the payment side of the right to know law. And I go into detail on how to deal with frivolous requesters. So you want to maybe make sure your schedule is open for that webinar if you have that sort of problem. Or you can reach out to our office directly and we'll try to provide some advice. Okay, but you cannot force a person to tell you why they are filing a right to know request. And the other thing you can't do is limit the number of requests or the number of records that a person asks for within a specific time frame. You can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. If she's inclined to file a dozen requests, the law allows her to do that. But again, if it's a frivolous requester, there are some things that you can do to make that go away. Okay, I like to describe the whole right to know process as an obstacle course. Okay, the start is when you first receive a request. Then there are hard deadlines built into the right to know law process for providing responses. And that's kind of similar to a time standard, where if you even want to enter the race, you have to make sure you can run it under this specific time. Then on this obstacle course, there are 2 hurdles. In front of the second hurdle, there are 3 hoops that you have to get through. Now, if you make it over the second hurdle, you're more or less saying, this is a public record, and we're going to grant your request and provide it to you. Okay, you've successfully made it through the obstacle course. Okay, so that's the premise that I'm using to kind of describe what we're going to be looking at over the next several slides. So you receive the request, the agency receives the request. What do they have to do? Well, the law says you note the date that the request is received, either on, using a timestamp or date stamp or whatever, or just write it in the corner. This is important because once the request is received, the agency has 5 of their business days in which to provide an initial response. Okay, now what is a business day? Well, it's a day that the agency is open to do business with the public. Okay, so Saturdays and Sundays are not business days. Holidays like Memorial Day would not be considered a business day. If there's an emergency weather closing, okay, because of snow or storms or whatever, it's not a business day. There are many like small townships, small boroughs in Pennsylvania that do not operate on a Monday through Friday schedule. Let's just say they're only open 2 days a week. Okay, hypothetically Monday, Tuesday. So a request comes in today. Okay, well then next Monday would be the first business day. Then you have Tuesday. Then you go to the second week, Monday, Tuesday. Then you go to the third week, Monday. The close of business that Monday would be your 5th business day. Okay, that's how that's calculated. All right, Julie, we received a request 11:59 on Friday. Do I date stamp it Friday? Well, you wouldn't be there to date stamp it at 11:59. No, your next business day would be, assuming that you're open on Monday, that would be your first business day, following the example that I just gave you. All right. Then the question often comes up about police departments. Police departments are a 24/7 operation. Well, it comes down to, when is your administrative office open to do business with the public? Typically, that would be a Monday through Friday operation, 8 to 5 or whatever, something like that. But again, if the administrative office is closed for a holiday, that's not considered a business day. And you would, work from that model. Now, here's an area that can be a little confusing. How long must you hold on to right to know materials? The right to know law says 30 days or until all appeals have been exhausted. When we're talking about appeals, you need to recognize that right to know requests, if they're denied by the agency, can be appealed to the Office of Open Records. If the Office of Open Records denies it, or even if they grant it, it can be appealed to, if you're a local agency, it can go to your county court of common pleas. Conceivably, a right to know appeal can go all the way up to the Pennsylvania Supreme Court, and that takes years. Okay, so under the right to know law, you would need to hold on to all those materials until all appeals have been exhausted. But then there is another law that would apply to municipalities, not school districts, not authorities, okay? School districts, I don't believe, have any law that governs, from an umbrella perspective, retention laws. The Pennsylvania Municipal Records Act applies to municipalities, and it says you hold on to right to know materials for 2 years. After 2 years, you can then discard those records. Okay, and the Municipal Records Act takes a look at what do municipalities typically have, what do they possess as far as records, how long should we hold on to them? And it covers right to know materials. Okay, my recommendation is follow the Municipal Records Act. Hold on to right to know materials for 2 years, even if it doesn't apply to you. Okay, 2 years I think is a good figure. After 2 years, then you clear everything out. It's not in your possession. You don't have to worry about it. Okay, another question. If I receive a request at 3 p.m. on a business day, when does the countdown start? Okay, well, legally, the countdown starts when the request is received by the open records officer. But let's assume that you're the open records officer. The countdown starts on the following business day, as your question says, and as I used in that example. If you receive a request today, tomorrow is your first business day. Okay, that's when the clock starts counting. Okay, hopefully that answers your question and gives you an idea as to how to apply that. Okay, moving on. Extensions. Now, we talked about the 5 business day window for providing the initial response. But what if, for a number of reasons, we can't really give you a definitive yes or no within the 5 business day window? The right to know law allows you to allows the agency to unilaterally invoke a 30 calendar day extension. A calendar day is different from a business day. Calendar day, you pull out your calendar, and starting on what would otherwise have been the 6th business day, or actually the day after the 5th business day, you count 30. And then that would give you the 30th calendar day. However, for the extension to be valid, there are some conditions that need to be met. First, you need to invoke the extension within the 5 business day window. You can't wait until what would otherwise be the 6th business day, suddenly realize, oh my gosh, I forgot about this right to know request. We're just going to take the extension. Unfortunately, at the end of the 5th business day, you denied the request by default. Legally, it's what's called a deemed denial, if you see that phrase. Okay, and that simply means that the agency failed to respond within the 5 business days. You need to notify the requester in writing that you're invoking the extension. And if you have an email system where I submitted my right to know request by email, you can simply respond back to me with an email. Hey, we're taking our extension. You need to provide a reason as to why you're taking the extension. And if you go to section 902 of the right to know law, it lists 6 reasons. It could be that we keep these records off site and it's going to take us longer than 5 days to go find them and go through them and figure out what's public and what's not. It could be our solicitor needs to review these to make sure we don't give out anything we're not supposed to. It could be that, just due to our current workload and the light staffing that we have, we're not going to be able to provide you with a response within 5 business days. So we'll provide you with a response within 30 calendar days. And you need to provide a date as to when they can expect to get the response. Typically, that's on the 30th calendar day. And then you need to provide an estimate of any costs that the person can expect to incur. It's just an estimate. It's not a hard quote. It can be a little high. It can be a little low. You settle up when it comes time to provide the actual records. So you've got the 5 business days, and then you've got the 30 calendar days that get tacked on to the 5 business days, which is why, I use the term 35 days in general. Now, let me also say that with the extensions, use these only if you have to. Okay, there are some agencies that just automatically invoke the extension, even though the record is clearly public and it's clearly readily accessible. Okay, that really upsets people. And if you don't have to invoke the extension, please don't. Okay, some agencies use it as an attempt to throw cold water on the process. It doesn't work. It just upsets people and makes them angry at you. And you don't need that. Okay, now I realize many agencies, you've got limited bench strength. The administrative staff wears several hats. Maybe there's only one of you and you're part-time, and there's just no way you can get to it within 5 business days. So you've got to do the extension. I understand that. But if you don't have to, go ahead and send out the records within the 5 business day window. All right. And life just ends up working out easier for you if you can. Okay, so we're up at the first hurdle, and we have to answer the question, is it a record? All right, seems rather obvious. Someone submits a right to know request asking for a record. Well, why wouldn't it be? Well, it's because all day long, we generate communications that do not meet the definition of a record. Whenever someone's trying to understand the law, and in our office, the 2 big ones are the Right to Know law and the Pennsylvania Sunshine Act, but even other laws, I recommend that you also read the definition section. Right to Know law is no exception, because within the Right to Know law, there's a definition of what is a record. And, this is just part of it, but any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, the key phrase is highlighted there in red, documents a transaction or activity of an agency. All right, let me translate that into English. It means that a record has to reflect what our agency is responsible for in the business that we're doing. So what if I send an email to one of my coworkers? Hey, did you hear about the new restaurant that opened up downtown? You want to meet for lunch tomorrow? Has absolutely nothing to do with the Office of Open Records or the mission that we're tasked with. Thus, that email is not considered a record because it's not documenting a transaction or activity of the agency. So if someone submitted a right to know request for all of George Speece's emails, that one would not be considered responsive. It wouldn't be included because it's not considered a record under the right to know law. Other examples, what do you think about the trades that the Eagles are making and how it's going to affect their chances this fall? Or I'm picking up a gallon of milk on the way home tonight. All right, all fairly common communications that you might find in any office, but they're not records. So I don't have to worry about them being released through the right to know process. Now, let me change this up a little bit. What if I'm at home on my personal computer, on my personal Gmail account, and I send an email to one of my colleagues saying, hey, could you send me the submissions related to this particular appeal, because I want to review the decision on it. Just because I'm using my personal equipment and I'm at home and I'm using my personal Gmail account, that message does document a transaction or activity of the agency. Okay, it reflects what I'm doing as part of my job with the Office of Open Records. So that email would be considered responsive. Even if I'm using my cell phone and sending a text to, one of my, let's say I'm sending it to Liz Wagenseller or Nathan Byerly here at the office, that could be considered a public record, even though I'm using my personal cell phone. Now, there's nothing illegal or wrong with using personal accounts or personal devices, but you need to understand that the messages are discoverable under the right to know law. Okay. One of the very earliest court cases related to the right to know law, in essence, says you cannot use personal accounts and personal devices to hide the public's business. All right. Just so you're aware of that. Moving on. We've made it over the first hurdle. We've determined, okay, it is a record. Now we're coming up to the second hurdle. And remember, we've got these three hoops in front of the hurdle. And here we have to answer the question, is it a public record? Notice the difference. Hurdle 1, is it a record? Hurdle 2, is it a public record? And that question gets answered by going through the three hoops. The first hoop, do any exemptions apply? And if so, are we going to invoke them? All right, what the heck is an exemption? Well, you go to section 708B of the right to know law. There are 30 exemptions. An exemption is a definition of a record that provides a rationale for withholding it. It's basically saying this is confidential, this is sensitive, and the agency at its discretion can withhold this from release into the public domain. For instance, 708B1, I think it's, to paraphrase, if by releasing this record, it would put someone in physical harm, we can withhold it. There's one in there about computer systems. If by releasing this record, it would put our computer system at risk. There's another one that deals with health records, the health record of a public employee. You obviously would not release that. There's one that deals with minors. Okay, if by releasing this record, it would disclose information about a minor, you can withhold it. Okay, now there's 30 of them that covers an incredibly broad spectrum of records and information that the agency at its discretion can withhold. Remember when I said the right to know law is not a confidentiality law. What the right to know law says is that if you receive a request that is clearly covered by one of these exemptions, you may withhold those records. It doesn't say you must withhold those records. All right, so the right to know law gives you the discretion to release those records, even if they are clearly covered by an exemption. And you can go to our website, go to the final determinations database, and you can actually search on each exemption to get an idea how we have ruled when it comes to records that are covered by those exemptions. Okay, so then we come up to the second hoop. And now we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? Again, covered in section 306. And this is a little different than an exemption. There are any number of laws, whether it be federal or state, that make certain records confidential. And if that's the case, those laws trump the right to know law. Okay, they supersede the language in the right to know law. Section 306 clarifies this. So that if you have another law that says this record is confidential, for instance, this police intelligence report, okay, is confidential, that means you cannot give it out. There is no discretion. It trumps the right to know law. Even though the right to know law says I can give it out, this law says I can't. So that law prevails. Some examples, in Pennsylvania, there's a law called CRIA, the Criminal History Records Information Act. If a record in the possession of a law enforcement agency is covered by CRIA, they can't give it out, okay? There's no discretion. The law says you don't give it out. School districts, there's a law called FERPA, the Family Educational Rights and Privacy Act, that says you cannot give out individual educational records, okay? Even though right to know law gives you discretion, FERPA does not. So FERPA prevails. All right. And there are examples like that. Again, we actually do another webinar on laws that protect information. You might want to sit in on that because you need to be aware of what these laws are so that you don't violate them in response to a right to know request. Like I said, there are a lot of tools that protect confidential information. Okay, and then we come up to the third hoop. Is the record protected by privilege? Okay, privilege here we're talking about, for the most part, attorney-client privilege, dealing with your solicitor. Any sensitive information that is exchanged between an attorney and their client is typically covered by attorney-client privilege. And this, reducing it to the agency scenario, if you've got a chief counsel or a solicitor who is providing legal guidance and legal advice to, your senior management, your counsel, your executive directors, whatever, okay, chances are that communication, those emails, those reports, those letters, whatever, are protected by privilege, and you would not release those. And again, you can, the reference in the right to know law is section 305. Okay, so we've made it through the three hoops by determining that there are no exemptions, or if there is, we're not going to worry about them. There are no other laws that say these records are confidential, and attorney-client privilege doesn't apply. So we've made it through the three hoops. That allows us to jump over the second hurdle. And we're saying, yes, we're granting your request. These are public records. We're going to provide them to you. Okay, that's how the obstacle course works. But before we provide the actual records, maybe the person owes us some money. Maybe they have to pay for them. So let's spend a little bit of time talking about payment issues. Okay, an important provision that everyone needs to be aware of is that the agency is only required to provide the record in its current medium. Okay, this is addressed in section 701. What does this mean? It means basically hard copy versus electronic. And it's what medium does the agency have the record in its possession? Let me give you an example here that will hopefully explain it. Let's talk about building permits. And let's say it's a borough, and the whole process is paper driven. Okay, I'm a homeowner, I'm a contractor, whatever. I apply for a building permit. I fill out a form, I attach drawings, specifications, and the like, and I send it in to the borough. Okay, it goes to the codes guy, or maybe the building permit division, whatever. And their review, all their correspondence, again, is paper driven. They approve the application. They issue a permit. That's a piece of paper that goes back to the homeowner or the contractor or whatever. And then at the end of the day, everything gets filed into a file folder and put in a file cabinet. Okay. Then someone submits a right to know request. I would like to see, and they submit it by email. I would like to see the file on this particular building project, including, all that stuff that's in the file folder. Well, and they say, I want it sent to me electronically. And they do that for two reasons. First, it's easy, okay? Email is easy. Second is that there's no charge for electronic records. But it turns out the borough doesn't have any electronic records. All of our records are in hard copy medium. Okay, so the question comes up, well, what do? The borough can respond back to the requester. We have those records, but we only have them in hard copy. And Section 701 says we only have to provide them in the medium in which they exist. So we will make copies, but then you have to pay. And if you're familiar with the right to know law, you can charge up to 25 cents a page. But the agency is not obligated to scan any records in, because that would be converting them from hard copy to electronic. And according to this language in Section 701, you don't have to do that. Now, you can scan them in if you want to, but you cannot charge for electronic records. Okay. And just as an aside, the Office of Open Records, if we don't already have it electronically, we typically will scan them in and just send them to the requester, because it's easier for us to do that than to go through the whole hard copy invoicing process. Okay. So that's what we do, but there's nothing in the right to know law that says you must do that. Actually, what the right to know law says under Section 701 is that you don't have to do it if you don't want to. All right, because it's a misunderstanding that people say, well, why can't I charge if I have to scan the records in? Usually, you don't have to scan them in the first place. Okay, you can if you want to. It's just that you cannot charge for electronic records. Okay, then there's a thing in the right to know law called inspection. A requester has two options. They can request copies, or they can request to come into the office and inspect the originals. All right, but when that happens, the agency's in the driver's seat. The agency can determine when during typical business hours it is convenient for the person to come in and look through the files. The agency can supervise the inspection. Okay, you can sit there and watch and make sure nothing is altered, stolen, or destroyed. You're in the driver's seat. If the person takes out a cell phone camera and takes a picture of the record, they're allowed to do that. As a matter of fact, they can bring in their own copier equipment as long as it's not disruptive to the office operations. Okay, agencies cannot charge for labor. Every so often we'll see a website out there where the agency is saying, we're going to charge you, X number of dollars an hour to process your right to know request. You can't do that. It's simply considered the cost of government doing business. You can't assess a redaction fee. You can't charge for any legal review, whether it's an in-house solicitor or some sort of outside counsel. You can only charge actual costs that can be documented, like postage, for instance, if you're dealing with hard copy. Okay. All right. A couple more payment issues. You kind of got the gist from my comments. There should be no surprises. And I want to make it clear. Let me get a sip of coffee here. Excuse me. There's nothing in the right to know law that prevents the agency and the requester from talking to each other. Okay. There's nothing that says when you receive a right to know request to do a quick estimate and pick up the phone or send an email back to the requester and say, we think this is going to cost you about $30. Are you okay with that? They're either going to balk and say, wait a minute, I misunderstood. I thought the right to know process was free. I'm not willing to pay the $30, so I'm withdrawing my request. Okay, that could save you a lot of work simply by picking up the phone. Or they could say, yeah, that sounds reasonable. I was kind of expecting that. Please go ahead and process my request. Okay, so communication is good. It could save you misunderstandings, and it could end up saving you a lot of work. Now, ideally, there is a mutual exchange, records for the money, but the right to know law says that records are provided upon payment. That means you get the money first, then you provide the records. Now, I think it's a good time to mention another common misunderstanding. When we talk about the deadlines in the right to know law, the 5 business days, the 30 calendar days dictate when the agency is required to provide a response, meaning we're either granting your request or we're denying your request, not when you're providing the actual records. Okay, let me repeat that. The deadlines deal with when the response is due, not when the records are due. So you can grant a request. You can say, yes, we're going to give you the records you're asking for, but it's going to cost you $30. When you send us a check, and when that check clears the bank, we will then provide you with the records. Okay, and you do that within a reasonable period of time. Usually it's a couple of days. All right. So you see how this works. Now there's even a provision within the right to know law that says if it looks like the response is going to exceed $100, send us the full amount before we even begin processing, before we even tell you whether it's granted or denied, and what specific records we're going to provide you. If it looks like it's going to exceed $100 for all the copies we have to make, you give us a check for the full amount, or what we estimate to be the full amount. I like to refer to this as a security deposit. This way, the agency doesn't get a right to know request, make all these copies, and then the person disappears and never pays for the copies, and you're stuck with all this. Okay, so you can demand that payment up front. Now, what if you get a right to know request and you arrange for the person to come, you grant it, and you arrange for the person to come into the office, and they'll pick up the records and pay for them at the same time, but then they never show up? Well, the right to know law, section 905, basically says if they don't show up within 2 months, 60 days, and you've made all these records, you can now discard the records. You can throw them out, shred them, recycle, whatever, dispose of them. But what if it still costs $30 to print out all those records? That cost does not go away. Even though you disposed of the records, that person still owes you the $30. So what if later a right to know request shows up from that same person and they still owe you the $30? You can deny their request for non-payment. Okay, and it doesn't have to be the same group of records. It can be an entirely new group of records. If they owe you any money, you can deny that subsequent request for non-payment until that debt is settled. Just make sure that all your I's are dotted and your T's are crossed, because it is a denial and they can appeal that. And when the appeal comes into the Office of Open Records, the appeals officer is going to ask for all your documentation. They're going to want to see all the communication. They're going to want to know how you calculated the figure for the debt. And, they want to make sure that the person was afforded due process and, that everything is legit. Now, I can say that in probably about 95% of the cases where there's an appeal filed over a non-payment issue, the OOR has ruled in favor of the agency. They've said, yes, this is a valid debt until it's settled, until the requester pays up. The agency doesn't have to process any further right to know requests. Okay, and there's no statute of limitations. The debt doesn't go away after a year, 5 year, 10 years. Okay, just keep that in mind. Okay, moving on. What if you've decided these aren't public records and we're going to deny them? Well, you have to notify the requester, and there's a format for the notification letter. Okay, first is you put down a description of the requested records. You're thinking, well, you know, why would I need to do that? I know what the person's requested. Well, sometimes it's not clear, okay? The person's not an attorney, but they play one on TV and they write something on a lot of legalese that doesn't necessarily make sense. You're putting it in your words. The agency's putting it in their words, what they think. This is what you're asking for. Okay, you're more or less framing the issue. Okay, and then you need to state the legal and factual grounds for your denial. Why aren't these records public? Usually what happens is you cite the appropriate exemption within the right to know law. Now, I've got this highlighted or bolded and underlined because this is where the rubber hits the road. Remember at the beginning where I said it is the agency that bears the legal burden. This is where you satisfy that burden. So it's important that you make the nexus between what the person's requesting, what provisions of the right to know law or other laws deem these records confidential, and why those records fit into that provision. Okay, you're making your legal case. Okay, and then you put the contact information for the arrow, because remember, this is the person legally responsible for responding to the right to know request. The date of the response, because now another deadline kicks in. And then finally, the procedure for filing an appeal. And usually there are exceptions, but you've got 15 business days to file an appeal with the Office of Open Records. I recommend putting down the OOR's website address as the point of contact, and that would be your denial letter. Okay. Now, when the person files an appeal, I'll just go through this briefly. The person, like I said, has 15 of the OOR's business days to file an appeal with our office. Usually that's Monday through Friday. Okay, when a person files an appeal, we have 4 elements that we look for. We need a copy of the original request, a copy of the agency response, provided there is one, a statement about why they believe the records are public, and a second statement about why they think the agency denial is incorrect. All right, and there are some generic languages, or I'm sorry, generic statements provided on the appeal form when they file electronically on our website. So what if one of these elements is missing? Well, we issue what's called a deficiency order, where we give the person usually 2 or 3 days, correct the deficiency, or we're going to dismiss your appeal. If all 4 elements are satisfied, then the case gets docketed. Okay, and docketing means it gets assigned a number. It gets assigned to an appeals officer, and we send out notice to the agency and to the requester with instructions on how things work from this point on. Okay, so it's, again, it gets sent out to the agency open records officer, so it's important we know who that person is. Now, this is probably, if you're here with us today and you're new as an agency open records officer, this is probably the most important piece of information you're going to hear. If you receive one of these notifications from our office that an appeal has been filed against your agency, run, do not walk to your solicitor's office and notify them that you have received this appeal. In essence, when someone files an appeal, they are suing you. Everything that I have described up to this point is what I would define as an administrative process. When an appeal is filed, it suddenly becomes a legal process. The Office of Open Records has been defined by the Pennsylvania Supreme Court as an independent quasi-judicial tribunal. In English, that means that we are a court. Our decisions carry the weight of law, and they can be appealed up to higher courts. Those higher courts require that we follow all appropriate legal standards and legal processes. Therefore, we have to require that of you. Your solicitor will know how to do that. As an arrow, you are not expected to know how to do that. And please don't try, because nothing is harder than having to deny a request, or I'm sorry, grant a request based on a procedural error from the agency because the solicitor was never involved. Okay, the arrow will still be boots on the ground, probably have some responsibilities to fulfill, but it is the solicitor who now becomes the point person in working with the Office of Open Records. Okay, that's really important, folks. Don't take this lightly. So if you get notice of an appeal, give it to the solicitor right away, because there are deadlines that the solicitor now must meet. And you don't want to abrogate your rights by failing to notify the solicitor in a timely manner. Okay, really important. Like I said, the product of an appeal is what's called a final determination. That is our ruling. It looks like just what you would see coming out of any court. Okay, legally binding. We issue them within 30 days of receiving the appeal, and you can find them on our website. If you have access to a legal service like Lexis or Westlaw, they're also posted there. There are a number of court or legal firms that also post all our decisions. So you can Google the docket number and usually find it. It'll come up in your search. Okay, like I said, I should mention this. Mediation is an option available. Every so often, you get the impression that the parties are not really communicating. Mediation allows the parties to do that. We have trained mediators on staff that if both parties agree, the case gets assigned to a mediator. Sometimes all it takes is a conference call. You get people talking to each other, you gain an understanding, and usually some sort of agreement can come. And I'm going to say, I think it's a little better than 50% of cases that go to mediation, we are able to arrive at some sort of agreement and the case goes away. If they can't agree, it gets assigned back to the normal process, and the appeals officer will deal with it as they would, if it didn't go to mediation. There's nothing that says you must go to mediation. It's simply a service that our office provides that sometimes can make the whole thing easier. Okay, and then like I said, our decisions, whether you're on the agency side or a requester, if you disagree with our decision, you can appeal it to a court. If it's a local agency, like in a city, township, borough, school district, whatever, it goes to your county court of common pleas. If it's a state agency, it goes to the Pennsylvania Commonwealth Court. You have 30 days from the date of our decision to file with the appropriate court and take it from there. You must notify us that you are filing. We are not a party to the appeal. We are simply a lower level agency that's made a decision. The dispute still exists between the requester and the agency. But you notify us because we will monitor the case. We may file pleadings, and in limited instances, we may request an appearance before the court if it's really a really important point of law. Okay, but like I said, we're not a party to the dispute. Okay, we are at the end of the presentation. If you have any further questions, now's the time to get them in. In the meantime, I just want to make you aware of additional resources. You've heard me referring to this website. Okay, well, here's the URL for it. You know what's coming. This is the best government website you will ever encounter. Okay, it is updated 6 days a week with new information, decisions from our office, court decisions, training opportunities. There are resources available to the public, to agencies. I mentioned the final determinations database. You know, there are over 30,000 decisions in this searchable database that you can go in and dive into and see how we've ruled on similar circumstances that you might be dealing with. There is a guidebook for all of you new right to know officers, 78 pages you can download for free. A lot of examples of sample language and processes that you can use to track your right to know requests. And then, like I mentioned, the training page, the PowerPoints, the recordings, etc. If you are a real geek about government transparency, maybe you want to subscribe to our Twitter feed, where every morning at 7 a.m. we will wake you up with a tweet that includes all the news of the day related to government transparency. And finally, if you have any questions, feel free to reach out to our office, either through email or just call on the phone directly. And like I said, you'll get one of our administrative staff who are really crackerjack people aware of what's going on with the Right to Know law and the Sunshine Act, and they'll help you out. Okay, but I want to thank you for your attendance today, as well as the very good questions. What did I do? My screen just went blank. Okay, I think I mistakenly stopped sharing. Okay, but well, we're at the end of the presentation. So if there are any further questions, like I said, now's the time to get them in. Let me see if I can just scroll through this to make sure I have everything. No, it doesn't seem to be doing that. Okay, well, if you have any questions, contact our office. But again, thank you for your attendance today. And we'll be seeing you again on our next webinar in 2 weeks. Take care, everyone, and we'll see you on the next one. Oh, here, questions have popped up. I'm sorry. For whatever reason, the chat feature did not advance. So I'm going to go through these questions right now. And I apologize for not seeing this. I don't know why it didn't advance. Okay, what if the request is sent, let's say on Monday? Okay, but the arrow only sees it on Wednesday, meaning opening the email. Okay, it's going to come down to when the request was first received by the arrow. All right, and I would argue that if it came into your email and you were available to address the email, you received it. Okay, so you want to stay on top of that. Now, if you were out of the office, let's say you were on vacation, that's a different story. All right. Okay, next one. If we pull the requested records to be reviewed in person on site, but the requester doesn't show up for the appointment and doesn't reschedule when we pull the records, can we assume we fulfilled the request? Yes. If you made a good faith effort to comply with the request for inspection, you should be okay. All right. And I don't know why the person would file an appeal in response to that, but let's say they did, I would say you would be on solid footing. Okay. My agency is open on Fridays, but I'm doing a 4-day work week. If you're not available, if you don't work Friday, does the Friday count? I don't know. Okay. When you get into these alternate work schedules, William, there's no litigation that provides guidance on that. I wish I could give you a better answer. As a rule of thumb, we've said when the office is typically open for business. Okay. Can you impose fees for ORR? Okay, I'm assuming OOR. I'm not sure what you mean there, Joan. Okay. Vicky, there is a scam out there for Right to Know. How can we know this without compromising our computers? Is it a habit just to open and respond in kind to the email? Okay, if you believe there's some sort of security issue whereby opening an email that's labeled as a Right to Know request, you would compromise your IT resources, you can take whatever steps you feel is appropriate to do that. I see that there's questions coming up about FOIA Buddy. So far, we're treating those like legitimate requests, but we have a notice on our website that gets more specific about our current posture with FOIA Buddy. Take a look at that notice on the website. And if you have any further questions, reach out to our office. If you have concerns, if, for instance, your malware software sends up a warning, then treat it as such, okay? Don't compromise your network or your computers if you think the email is, has a virus or something like that. But document everything in case it does prove to be a legitimate request. And that way, you can deal with it accordingly when all the virus stuff is sorted out. Okay, David, and again, I apologize why we're dealing with a new system here for, the Commonwealth imposed it on us. It's called, what's the name of this thing? ClickShare, and it is just a bear to work with. It's really been a step back when it comes to the chat feature. But it says, okay, so David, how can an agency deny records of a proposed development that will be voted on in a public meeting when the records are sent into the agency for approval? Section 708B17 cited as the reason for denial. Okay, B17 is a non-criminal investigation. Without knowing the specifics, I would say that a zoning ordinance, that's a bit of a stretch, but it's not for me to determine whether that's appropriate or not. If you are in disagreement, David, with the agency response and their referral to B17, you have the right to appeal that. Now, I'm not saying your appeal will be granted. I'm just saying you have the right to appeal that. There's no cost to file appeals. You do it on our website. Okay, and then we're getting to the end here. Okay. Mark M, how do we handle broad requests? Okay, copies of requests for all fence variances from 1980 to present. All right, well, the first thing you have to do, Mark, is determine whether or not the request is specific enough. Section, I think it's back to 701. It's either 701 or 703. Says that the request needs to be specific enough that the agency can determine what records are actually being asked for. And there are some standards to that. If they have a specific date period, well, that's specific enough. There's a difference between a request not being specific enough to one being overly broad. And the first question I would ask is, do you in fact have records that go back to 1980? And if you don't, then you're not in possession of the records. But it may be that you actually have to do a little bit of work to go back to all these fence variances. It comes down to, do you in fact have the records, and how readily accessible are they? You may have to physically go through and take a look. In an instance like this, you might want to reach out to the requester and ask them, why are you filing the request? You can't deny a request, or you can't force a person to tell you, but that doesn't mean you can't ask. And, maybe they've got some specific issue that they're dealing with that you can help them out with and save yourself a lot of work. If they're just asking for all these fence variances because maybe theirs was denied, take a look at what's the cost going to be to make all these copies of fence variances back into 1980. And are they willing to pay? If they're not willing to pay, well, then your problem is solved there. Okay, Kimberly was late. Yes, it's going to be recorded. Yes, you can watch it on our website, hopefully within the next couple of days. David, again, okay, how can an agency deny records of a proposed development? Did I read this before? Yeah, okay, for whatever reason, the chat is bouncing around. Gosh, I hate this thing. Okay, if you request the Daisy, if you request the 30-day extension, say 2 days after you receive the right to know request. Oh, good one. Yeah, it's 35 days, Daisy. It's the 30-day extension begins after the 5th business day. Doesn't matter when you invoke the extension. Okay, FOIA Buddy. Yeah, Janice, you want to take a look at our website. We're familiar with it. We have some concerns, as do many of you, and it's addressed on the website notice. Okay, going through more of these. Yeah, more of FOIA Buddy. Okay, I have not had direct work with this because I'm not really an employee. I'm a annuitant/consultant, but I know that the office is on top of it. Okay, what happens when the arrow is on vacation, Callie? Yeah, it's when the arrow returns from vacation that the clock starts ticking. But what I recommend is that you communicate with the requester that the arrow is out of town and that the clock will start ticking. Clock starts ticking when they return. That way everybody's on the same page and there's no misunderstanding as to when the deadlines actually occur. Yeah, requests about FOIA Buddy. I was warned that you guys would have a lot of this. So, yeah, okay, somebody has posted the FOIA Buddy notification off of our website right here on the chat. Okay, well, that's cool. That's one thing that I like about this. Janice, yeah, more FOIA Buddy. Okay. Would FOIA Buddy fall under the definition of a vexatious requester? It might, but there's no reference to a vexatious requester in the right to know law. You are referring to proposed legislation that is not law, the term vexatious requester. And my guess is FOIA Buddy might speed that along. Never really seen anything come out of the legislature to deal with this, but you know, it's possible. Okay, Janice, back to big request. Please provide multiple documents that collectively cover the requested information. That may not be specific enough, but I would suggest having a discussion with your solicitor if there's anything that raises the question about you know, whether or not a request is specific enough. And again, we've got a lot of language in our final determinations database on how to deal with specificity. Dawn, 92 requests from FOIA Buddy. Lucky you. Okay. I know that this is going to be dealt with. Okay, it looks like I am at the end of the chats and the end of the questions that came up. Again, I apologize why this thing didn't advance. I think I had the same problem a couple of weeks ago. What a pain. Okay, but that's not your problem. We'll try and get someone in here to solve it. Okay, yeah, Janice, you're welcome, and thank you for your patience in dealing with this. Now I'm going to sign off. Okay, it looks like we're at the end. Is FOIA Buddy considered an anonymous requester? That we've had that discussion, Aaron. I would take a look at it. I would also take a look at what your agency policies are with anonymous requesters and whether they may apply. Okay, it may be the solution to your problem. Yeah, I haven't looked at it directly, but I know those discussions are ongoing. Okay, now I think I'm at the end. Okay, it looks like everybody's done with the questions. Thank you for your nice comments. And I'm logging off. See you next time, folks. Take care.